We are live, Madam Chairman.
Thank you. Welcome to the Senate Ag Committee meeting. Today we'll be beginning with Senate File 65, Temporary Water Use Agreements, and Senator French. We will do roll call, but I was notifying you because, no, that's fine, because we had noticed the other bill first, I believe, but we'll start with Senate File 65. Would you please call the roll?
Senator French,
Here.
Senator Hicks,
Here.
Senator Ide,
Here.
Senator Kolb,
Present.
Senator Larson,
Here.
and Chairman Steinmetz.
Here. All right, to take us through these two bills will be Senator Hicks. These were kind of his project over the interim. He brought them to our Select Water Committee. So take it away, Senator Hicks.
So, Madam Chairman, I don't know that it would be 100% accurate to say these are something that I brought. It's actually an issue that's, that's been out there for quite a while. It's just becoming increasingly important as we start to deal with the potential curtailment or a call on the Colorado River and the implications of that to the state of Wyoming and all the water users within that basin. And so it's something that we've looked at some of those advisory committee meetings. Select Water looked at this and took this up. So these are mostly, so specifically to Senate File 65, there's really only one policy substantive change in this. The effect of this is, and I want to bring it to people's attention. If you go into this bill and you look at 41.3.110, now that's going to say right to acquire temporary water rights, applications, restrictions, and fees. And so the very important thing in here is what 41.3.10 currently says in statutes is right to acquire temporary water rights for highways, for railroads, roadbed construction, or repair. And so this kind of come to a fruition when we were working on some other water bills last year, and we had our legal staff. I told them I wanted to bring in the concept of, or the statutes that under a temporary change, if you had a prescriptive easement and you exercised the right under a temporary change, that you wouldn't lose that water right. So I asked our LSO staff attorneys to do that. So they couldn't find where you could do temporary change of use within our statutes, because it says right to acquire temporary water rights for highways, railroads, roadbed construction, and repairs. And so we have done temporary water use agreements for decades in this state. And I think back to the coal bed methane days, and even currently now with some of the Niobrara drilling that's gone on over here in eastern Wyoming, a lot of road construction. We do temporary changes all the time. And typically there's a willing seller and a willing buyer, but it's a very temporary nation. The trouble is nobody could find out where that was in statutes. So I want to bring your attention to where that the state engineer's office for decades was granting those. And so if you go into the language that was stricken and you go to page 2, it goes in there and it talks about repairing railroad beds, highway construction, drilling and producing operations, and it has 4 words there. It says, or other temporary purposes. So if you didn't know those 4 words were in there, you would never be able to find where in statutes that you could use this to do a temporary change of use. So the whole genesis of this bill was just to bring the statutes up, make it transparent so anybody can find out where the statute is without having to read through lines and lines and lines and say, you can only do it for railroads and highway construction and all these others. So this bill is just a cleanup to provide additional edification as exactly where in the statutes you would find this component. And so it eliminates all that highway construction. So the genesis of all that language when we went back and looked at that, was when they were building the interstate highway system across the state of Wyoming back in the sixties, I believe. And we needed a lot of water and we didn't have any mechanism to do that. And so that's some of the background on where that came in. And that's why it had so much heavily focused on the Transportation Commission, highways, road construction, and all that stuff. But under those three words and other purposes, we've been granting temporary water use changes for decades. So this was just more than anything else as an attempt to make it clear where you find that in statutes, how you would do it, and what it does. The only substantive change in here is when we go from 2 years to 5 years. But it also puts a mandatory review on there by the state engineer's office. Before, you could do these 2 years consecutively for infinity because there was no provision to say you could not do those. And so when we get down those and we look at the duties of the state engineer, it says must review every 5 years and his discretion renew a temporary transfer. The point of that is now we have the state engineer is going to look at these and make a determination. Is this truly a temporary change of use? Or is this starting to look like a permanent change like we had under the previous process where you could do unlimited number of 2-year renewals? So it just puts a duty on the state engineers to say to review that. It's that 5-year period now. When they reapply for this, the state engineer will look at that, make a determination, is this really a temporary or not? And then he can either grant that or not. Madam Chairman, so that's what the bill does. That's the genesis of the bill, was trying to clarify in statutes what was eligible and how it would do. So, Madam Chairman, I guess with that explanation, I'd stand for any questions.
All right, thank you, Senator Hicks. I have one on page 3. And I apologize, it's been a while since we met on page 3, line 6 and 7, where we're striking whether prior or subsequent and inserting which is senior. Can you explain that change to me?
Yeah, Madam Chairman. So one of the things that we always try to do is make conforming language all the way through the statutes. And so what we found out is through most of the statutes in Title 41, we refer these to senior water rights. And so rather than call out priority here and senior someplace else, this is again just an attempt to make conforming language so it's consistent through all of Title 41, which is water law, that it will now say which are senior and priority. That's all that does, is try to bring in conforming language with much of the other statutes.
Follow up, whether prior or subsequent, what did that mean before though? Did that contemplate a junior right or not?
Madam Chairman, that's probably something that, and I remember now that when we were doing this, that was quite a debate, whether under these temporary changes that a junior would still be able to exercise that temporary change. With this new language, it says no, it's a senior. In other words, a subsequent, prior or subsequent. This just makes it definitively now that you can't, it's a senior and priority to a temporary right acquired by a person under this act cannot satisfy. It provides that any senior water right can call out a temporary use water right under the statutes. Like that, again, it's trying to clear that up.
Okay, so I would consider that a policy change there as well, besides the 5 years. But anyone else have questions for Senator Hicks on the bill? It's been a while since we've been in select water, and some of us aren't on select water, so Senator Larson, you were there, and Senator Kolb. All right, okay, then I guess we're ready to bring up our good mayor's office to visit with us about this bill. Welcome Gentlemen, good morning.
Good morning, Madam Chair. I'm Brandon Gephardt. I'm the state engineer. With me is Chris Brown from the Attorney General's office. We were fortunate enough to be included in the interim topic as well as helping with the drafting of this bill. And so I don't know that I have much to add to the discussion other than I think one of the reasons why this in the discussions with Select Water, why this was desired was to create certainty to folks who want to enter into these agreements. Provide a little more certainty to what the agreement does for them when they do enter into these agreements. If they're spending money or entering into agreements, they wanted a little more certainty. And I think that's where the 5-year came from, as well as the which is senior and priority. And I think the two policy changes were somewhat reflective of what we heard from public.
All right, are there any questions for, go ahead, Dan, Senator Larson.
Madam Chairwoman, thank you. So do you see any problems going from the 2-year to the 5-year? Is there any, I guess that's the question.
Madam Chair, Senator Larson, we had a lot of internal debate on that with the folks who would be out administrating these, and we found no significant issues going from 2 to 5. So we were comfortable with that.
All right, and I would have the same question for you on page 3, lines 6 and 7, whether prior or subsequent, and the change to which is senior. How do you see that working out?
So, Madam Chair, it's a good question, and I think the way we've looked at it in the past is that a junior or a senior could immediately call this off. What that means, though, is it is called off. The hydrographer will go out and investigate to see if there is an injury, and then either reinstate it or keep it off. One of the arguments that we heard is that if a junior calls it off, we go out and investigate. The concept is that had the exchange or the agreement not been in place, would that operating the way it's permitted without the agreement, would that have caused the same injury as it does with the temporary use agreement? A lot of times the answer is probably no. They would have the same injury if it was being performed as it was permitted as they are under this temporary water use agreement. And so then by just inserting the senior, then that's a little different analysis because will this hurt a senior? Would the original condition have hurt the senior? And if that's right, then it's shut off. And Chris, if you want to, I kind of butchered that, but Chris is more eloquent than I am.
Madam Chair, if I might,
Go ahead.
I think it's important to recognize kind of the timing with which that statute comes into play. And that's after it's put into effect, after the temporary transfer is actually occurring. And what it does is actually change the way that a typical regulatory response would happen, right? So in a current situation, if we get a call on the stream, a senior right's not being satisfied, the first thing the hydrographer does is not go shut off the temporary user. That's not the first step. The first step is to go to the senior user and make sure that they are in fact not being hurt. What this statute does in this temporary water use agreement context is say, no, the default is you go turn off the temporary first and then you investigate. So that's really the change that statute makes as far as a regulatory response to whether or not a water right is being satisfied. I'll point out that in the 110, the initial inquiry, the initial investigation the state engineer makes with regard to injury is all rights, all existing rights. So when a temporary water use agreement is applied for, the state engineer making their analysis will do an investigation to see whether or not that temporary will injure any existing rights. And so that initial inquiry applies to everybody, not just the senior rights. So the second statute is really just a kind of a switch in the regulatory response. What do you do as a hydrographer if a call is made by a senior user, now not just a senior or junior, but by a senior user? It's just you go automatically turn off the temporary and then you investigate. And so that's really the only change there. It is kind of how that response is made. And the policy changes, you're only going to allow that automatic shutting off if it's a senior user making the call, not a junior as well. It doesn't mean that there still couldn't be an investigation about injury after the fact, but it's just a change in kind of that timing of the response.
Well, I've got to, thank you for that. That helps. But I still have a concern, and I did at the last meeting, about the junior, because when they received their water right, things were working a certain way. And then now this change occurs, and if they're injured, what is their recourse? If it, if on the front end, we can't tell that there could be a problem, and then on the back end, they're injured, how does this apply?
So, Madam Chair, excellent question. And of course, you do have the front end analysis, but of course, you have to see how things play out on a stream sometimes to actually figure out what the
Right.
impact is going to be with regard to that particular change. And I think that there's still the opportunity, and I might be wrong, we might have to call up somebody else. But I think there is the opportunity, of course, in the orders that approve temporary water use agreements with regard to the hydrographers out on the ground actually administering those particular transfers to respond to the particular circumstance to see whether or not there's injury. So like I said, the back end statute 111, in my view, simply changes the timing or how a response is made to a call by a senior, but it doesn't fully answer the question that if there is some sort of an injury to another water right, I do not think that that precludes their ability to raise that issue to the hydrographer saying that action has injured me. And there's other processes in Wyoming state statute that allow a water right holder, if they believe that they are harmed by the action or inaction of a hydrographer, to appeal that decision up to the superintendent and then up to the state engineer,
All right.
ultimately to the court.
Right, and I, just 1 minute. I haven't read through these amendments yet, because they just were, is this gonna take care of it, Senator Hicks? Or, because, oh, this is 66, so, because when I, and no offense to you at all, but when I hear, I think, and it might, and with regard to water law, that's very ambiguous to me, and it, I'm wondering how we can fix this so we don't have that type of response, because I wouldn't want to be in a position where something occurred and be saying, I think we might, so to a water user.
Madam Chair, I might just add that any of these agreements, they are supervised by the hydrographer, the commissioner, or the superintendent. And it is, if there is a complaint that they're being injured, then it is investigated. If it's not investigated, there is in statute a process for an appeal that the hydrographer did not do it correctly, and then that comes to me. So there is a procedure for inaction by hydrographer as well as a wrong action by the hydrographer. So under these, under the supervision of the commissioner, everybody still has that right to claim an injury. And Chris is right. What this does is it just changes the timing. So if a junior is injured, he still has the ability to make a claim, and then the process is just like a call on any water right.
Okay, that helps a little bit.
Madam Chair, if I could add into that, and I apologize, my wishy-washiness is in part an occupational hazard. And it's in part just trying to, and we've talked about this quite a bit, where it's impossible, in my view, to prejudge a circumstance in Wyoming, because every one of our streams is different, because the water rights on those streams are different, the characteristics of the streams are different. And so I try to be very careful to try to lump everything in a general way. So generally, it's going to be up to the hydrographer to make a decision about whether or not the hydrographer thinks an injury is occurring to any other water right. What is absolutely true is that there's recourse built into the statutes for folks who think they are injured. They have the ability to appeal that up the line to get some recourse if they do not get an answer they believe is accurate on the front end.
Okay, all right. Senator Ide, sorry to keep you waiting.
No. Thank you, Madam Chair. No, I'm not on Select Water, and I have a question. I wasn't in on all of this discussion when this bill came because I wasn't on Select Water, but I've got a water right on a creek, and it's a senior water right. And what I don't understand, explain to me what the injury would be if the junior adjudicated water right was doing, they did their exchange and they were still using their allotment, nothing more. Where is the injury? That's where I guess I'm confused. Thank you.
I will start that, and Chris can jump in whenever. But under statute, a junior right is entitled to the conditions of the stream when he arrives. So anytime you make a change subsequent to his acquisition of that, there could still be an injury to that junior right from the context of he's entitled to the stream as it was when he made the right. So just making a change after he has a water right, even though he may not be senior, it could still cause injury as a product of a change after he came in. Does that help?
Madam Chair, if I could
Go
just
ahead.
add a
Go
little
ahead.
bit onto that, and I think that it illustrates the answers probably doesn't, right? But I think it illustrates the fact that we've got to wait until we get all the facts in front of us to make sure that's true. Because there's other pieces built into the statute, a whole section that's not included in this amendment that describes kind of a default. We're going to leave the consumptive use amount in the river. So try to keep the regular return flow regime as it's been historically experienced in the system that way. So it shouldn't impact other appropriators that are nearby. But once you start changing, for example, under a temporary where you take the water out, it could potentially have an impact to some other senior that maybe we didn't foresee at the front end or something. So there's the potential. And so we don't want to prejudge it. And so the statutes do provide the opportunity to say, well, wait a minute, we missed that or something, and make sure it's not injuring somebody else.
All right, Senator Larson.
Thank you, Madam Chairwoman. I guess I have I don't know, just a situation where, or I'd like to kind of clarify it a tad bit. If the junior water right, the way it currently is, if the junior water right thought he was being injured by the temporary use, it would automatically go out and shut the temporary use off. If we change it, the junior water right still has a right to say, hey, I think there's a problem here. It just doesn't get shut off right away. The hydrographer would go out there and check it out, is the way I would think this would go. I'm not sure.
Madam Chair, that's the way I would, yes, the answer is yes, that you would still have the right to claim an injury. The only difference is if it's a junior right, then it doesn't automatically shut it off, but they still have their due process for claiming a right.
Okay, Senator French. Oops, I'll go to French, then you. Sorry, I missed you. Go ahead. I've been missing you. Okay.
Thank you, Madam Chair. Can you kind of explain a little bit, say that way back in the 1800s, late 1800s, somebody on that creek homesteaded, whatever, and they got the senior water right, but they're way down the stream. And then in subsequent years, the junior to them are up above them, and it gets dry. And what happens at that point if the water gets low, can the senior water right holder down the stream say the junior ones, you need to shut them off? How does that scenario work? Thank you.
So, Madam Chair, Senator French, what would occur in that situation, if the senior calling right is downstream, the hydrographer would go first verify that it's a valid call, that he doesn't have the water available for his appropriation. And then by order of priority, they would go upstream of him and start shutting off head gates based on priority dates until there was enough water to satisfy the calling rights of the senior right. And it could be that they would have to shut everything off and he still may not have his water. But that's a function of hydrology and that's the most we can do.
All right, Senator Kolb.
Thank you, Chairman. Just for the record, I don't own any water rights, so but I did have a question about time. I mean, we talked about an investigation. You would look into if the complaint was given by a junior water right holder. How long would it take you to adjudicate that, if that's the right word, to figure out just what is right or wrong about the claim of injury to the junior in a water right conflict?
Madam Chair, that's a good question. And I think once a call is made, it is our strategic goal. I think it's 2 days. Within 2 days, we have it resolved is our strategic goal. Some of them may be more complex and we don't hit that, but it's a matter of a day or two.
Go ahead. Chris.
Just to add on to that to make sure it's clear that the 2-day response is the initial response from the hydrographer. So the junior user, and I think our hypothetical that we've been kicking around is the junior user would say, I think I'm being injured by that temporary water use arrangement. So Brandon's exactly right. The response to that claim of injury is generally 2 days. It's going to depend on the complexity of the circumstance, but generally 2 days. Then from that decision, if the appropriator doesn't believe they got a proper result, then they appeal to the superintendent of the water division. And then those time periods are similar as it moves up. The superintendent tries to turn it around within 2 days after that, or as quickly as possible. The appropriator then has the opportunity to appeal from that decision to the state engineer, and the practice is the same. You turn it around as quickly as possible. And the recognition being somebody that's without water for very long gets injured very quickly. And so the process in that scenario, that statutory process that's set up goes very, very quickly.
Follow up, go ahead.
Thank you, Madam Chair. So typically, are these resolved quickly, or does it take a little bit of time and does it have to be analyzed by, further people up the chain of command? I mean, how quickly do these get resolved?
Madam Chair, I'll use an example of one that I was involved in. And it was by the time the hydrographer was out, the appeal to the superintendent, then the appeal to me was resolved in a week and a half at the most. It was pretty complex, but I think typically they're handled within a week, if not less, for that's our effort, is to try to, like Chris said, people are being injured. We recognize that. So we do it as quickly as we can, but the facts and circumstances may change that.
All right, is there any further? Okay, Senator Hicks.
Madam Chairman, so with that explanation, Brandon, that was the worst case scenario going all the way through the process. Hydrographer makes a determination and then the superintendent makes the determination and that's appealed to you and then you made a determination and that all happened in 5 to 7 days.
Madam Chair, for that example, that is correct. And it wasn't very complex, but it was.
So the converse of that, how long does it usually take for the hydrographer to go out and make a decision that most of the times will withstand the appeals?
1 or 2 days.
1 to 2 days. All right, thank you.
All right, okay, further questions, Senator French.
Thank you, Madam Chairman. Just playing the devil's advocate here. So there's the senior water right holder downstream says, due to dry after the spring runoff, you know, geez, I'm not getting the water I need. So you start going upstream and saying, you need to shut down, blah, blah, blah. I've heard of cases where people upstream, you know, water's the lifeblood of a rancher or farmer, right? Your livelihood depends on that. Right at dark, turning the water back on and irrigating during the night, and, you know, just so the stream's full by daylight, they shut it off. What kind of penalties or how is something like that resolved or proven? I mean, I've heard of cases like that. What kind of penalties or whatever? Thank you.
Go ahead.
So, Madam Chair, Senator French, the hydrographers have the ability to go lock and tag a head gate in those circumstances. If they believe that something nefarious is occurring, they can actually put a lock on the head gate. If that head gate is then still altered with, they can go through the county prosecuting attorney to assess penalties, monetary penalties. There may be more, Chris can jump in, but locking the head gate would be the first thing. And then if that doesn't resolve it, then asking the county prosecuting attorney to assess fines is procedure.
Just add a couple of things. The state engineer is absolutely right. I just want to clarify that, you know, there are circumstances where just because the senior right downstream is short of water, it's not always true that turning off an upstream junior is going to satisfy that senior right. And so again, it really depends on the facts and circumstances of the stream. Just a very quick example, Gooseberry that's above Sheridan, it gets dewatered multiple times as it comes down the mountain. The senior right is down at the bottom. But because the return flows come back in, as those junior rights dewater that river, they don't get turned off because that senior right is going to be satisfied. And we have the concept of feudal call in Wyoming, that if by turning off a junior, it's not going to put any usable or material amount of water at the head gate of the senior, we're not going to turn off that junior because it doesn't do any good to the senior if we turn that off. As far as the penalties, the state engineer is right. You can find those penalties in 41.3616, if my memory serves me, and they range from criminal penalties to established, I think it's $1,200 or $1,250 a day for continued violation. There's additional provisions in that statute that allow the state engineer to take action against a water right. So there's quite some stiff penalties if there's some intentional interference with another right or interference with a hydrographer doing his job.
All right, I'm gonna get us back on track. I let us wander a bit just because these things are very important and it's a good time to educate ourselves a little bit. But since our strict time limit, we have to be gavelled in at 9:30. We have about an hour. So are there any further questions? Seeing none, you guys stick around in case we have someone we're working the bill. We'll go to public testimony now. Is there anyone in the room that would like to testify? Come on up. Please, welcome to the Ag Committee. Please state your name and if you're with an organization, and then proceed on. If you have green, it is on. So,
Here we go. All right, good morning, Madam Chair and the rest of the committee. My name is Cindy McKee, and sitting next to me is my
Cody McKee, Savory, Wyoming.
Very good, and we're representing ourselves today. We live in the Little Snake River Valley east of Savory, where we own and operate a cattle ranch. We first wish to acknowledge the tremendous challenges that exist as the state of Wyoming works to solve issues in the Colorado River Basin. And we know very well that there's very good, well-intentioned people trying to solve those problems. And we just want to commend those efforts. And we're certain that innovative solutions are forthcoming. However, today we must make you aware of what we see as some grave potential unintended consequences of Senate File 65 should it pass today. First, I want to help you understand the stakes. For us, we had a supplemental supply carried down a private 13-mile Belvedere ditch. It's the only source for irrigation and the only source of stock water all summer and fall at our headquarters after our Miller Creek original runs out in early May. Our legal historic diversion on Haggerty Creek for these beneficial purposes has rightly never been regulated. And that's because there's never been a substantiated shortage that required regulation and priority administration before. So that's and then for our diversion to suddenly begin to be regulated in any way whatsoever will necessarily deprive us of irrigated acres and a loss of land value. And to experience a full shutdown would, put simply, be catastrophic to our family business. So those are the stakes for us. That's why we're here. So here's our specific concerns when it comes to Senate File 65. Very specific temporary use, which also allowed other purposes, as was pointed out. You know, there's been many approved purposes over the years, has been changed simply to beneficial purposes. I want to point out that this word beneficial has real meaning and broadens the statute to include fisheries. They were not included before. This new pathway circumvents the appropriate rules and processes that were originally put in place to moderate the important decision of assigning any water rights to fish. I also want to point out that that designation, fish, changes everything. This particular beneficial use, it commandeers the entire upstream source in a way that irrigation and other uses do not, due to unique considerations for fish. It's a living thing that travels. The normal procedure to verify water at a headgate during a call for regulation and administer priority is thus bypassed. So that what was just mentioned is bypassed in that case. And the people who've always been able to irrigate before could suddenly lose this ability as they're forced to let water go by their headgate that they've never had to let go by before. We also really struggle with the contradictions. The same contradiction that's been under discussion today was that the 41.3110 is amended to say the state engineer shall not approve a temporary transfer if it injuriously affects the rights of other appropriators. And that sounds great, but we're troubled by what comes next, like some of you were wondering about. So what this says to us is that in the event that someone can't access the water they've always had before, they can only protest if their rights are senior. I think it communicates a very confusing message to the hydrographer commissioners, because it does, a plain reading sounds like those rights really aren't to be considered. And so I'm respectful of the explanation that was given before, but I'm still troubled by this contradiction. And I'm also troubled by the fact that under an appeal, like what was mentioned, is we're appealing eventually right back to the person who made the original decision. And our only remedy after that is courts. And so that's a little troubling to me, that it starts with one person and then the appeal comes back to that same person. Combined with a maximum 5-year term, renewable into perpetuity, because you'll notice there's no limiting language, this bill creates potential for serious injury to some of Wyoming's farmers and ranchers, in particular those lacking the oldest water rights. State engineer, we're seeing this from the ground level, as a political appointee, would have the sole discretion over these decisions with no accountability for him that we can find, save the governor. It's he or she alone that our understanding will determine the definition of injury. It's he or she alone who will determine which beneficial use is more important as compared with another. And this one person's decisions will be final with no means of appeal articulated that we can find in statute, leaving the injured no recourse but a lawsuit. We're here before this committee today because we have every evidence, every reason seen over a period of 13 years to know that we're very vulnerable, that this change represents a clear and present danger to us. Even if the language were restored to preserve or to protect juniors, we've learned through painful experience that we really can't trust the injuriously affects language. 3 different ways over 13 years, we've been both deceived and injured by what the layman reader would recognize as improper or illegal behavior. And I'm going to point out with the illegal behavior, the county penalties that have been brought up. In practice, that doesn't happen very much because the county attorney is the one who makes the choice about whether to prosecute. And that troubles me too. That's not a protection for me. And we've experienced that already. So when we try to remind people in the state about their duty to follow the law and written policies, you know, we find that the room for interpretation seems to be very, very, very spacious. And we also find that discretion often serves as a barrier to justice, quite frankly. So in every instance, it's been an appointee in upper echelons that have let us down. It's never the good people on the ground administering. They're doing their job. They're doing a tremendous job. But sometimes we even find that it appears to us from our experience that upper echelons are even at cross purposes with the people trying to administer on the ground. So these things trouble us. We have a history. We've had struggles. And we're seeing Senate File 65 as it currently stands as an invitation to mischief, malice, and injury, not only to us, but to unsuspecting comparatively junior water rights holders across the state. We do have the experience to understand that the ambitious, the covetous, and even the angry have a strong desire to profit or elevate themselves at the expense of others by using the power of government and territorial water rights. I'm so sorry to have to tell you this, but Senate File 65 provides a tool to act on these impulses. That's the way we see it. Madam Chair, we ask this committee and our own Senator Larry Hicks to please vote no on Senate File 65 unless fisheries are explicitly excluded and consideration of junior water rights are restored. Thank you.
All right, questions for the McKees? Any questions? Seeing none, thank you for being with us today.
Thank you very much,
All
Madam
right,
Chair.
thank you for making the trip. All right, any other public testimony on 65? Come on up. Welcome, Mr. Stewart, back to the legislature. How are you today?
I'm good. Oh, the green light came on. Thank you, Madam
All right.
Chair, for the opportunity to comment on Senate File 65 and to urge your no vote on this bill. My name is Jeb Stewart, and it's been a great trip back here the last couple of days, seeing a lot of old friends and people I used to work with here. I'm here today to speak on my own behalf, Madam Chair, on an issue of great importance to me and other water users in the upper North Platte Valley in Carbon County. I've been tracking these issues for some time now, since the first working group was formed to start discussions on demand management, which I was asked to be on. I have also previously commented on a previous draft water banking bill that appeared before the Ag Committee. Of some interest, Madam Chair, all of these discussions recognize that there is no new water available for appropriation, and that if you need new water, you either have to take it from someone else or make a deal with another appropriator to get some water. I have watched and listened to the recent discussions from Select Water related to the 2 bills the committee is sponsoring this session. And I'd like to bring up many things that were heard in committee and also speak to some issues that were not discussed or addressed. Speaker Summers summarized the purpose and need for these bills, similar to the ways the good senator from Carbon County explained them. To address potential curtailment issues in the Colorado Basin, in Wyoming, and the need and desire to move water around when or if it occurs, and to make sure there is clarity and certainty in our statutes to accomplish this. Madam Chair, it would appear the message from Select Water Committee to the people of Wyoming is that Wyoming's most important resource, water, is for sale. and it is for sale to the highest bidder.
Mr. Stewart, I really appreciate your comments, but could we specifically address the bill because we have a limited time frame today? And we have your comments before us that I promise you we will read. But could you tell us with regard to your thoughts on the actual legislation? Because I'm sure you understand our time constraints, having served in this body before. So if you could direct us back to the bill, what your concerns are specifically in the bill and why, that would be very helpful for us as policymakers. And we can see if we can make any amendments to the bill, or if you're just opposed to the bill, that would be very helpful for us.
Thank you, Madam Chair, for that direction. To preface my comments on 41.3.110, that part of the bill addressing 41.3.110. The process to change a water right, either permanently or temporarily, should be a very thoughtful process, Madam Chair, not streamlined for rapid approval. The broadening of 41.3.110 will allow anyone, the right to change their water right to a non-consumptive use, which includes for fisheries purposes, since during curtailment, the goal is to reduce consumptive use. Amendments to 41.3.110 have been proposed in the past as a way to allow temporary changes of water for fisheries purposes unsuccessfully. The fear is this bill may be successful in accomplishing this. The change of a water right to fisheries purposes temporarily can disrupt historic beneficial use for irrigation and also bring unwanted administration and regulation to our creeks and streams where there has been none in the past. Many of my friends and neighbors who just want to be left alone will be injured if this were to occur. Clearly, many special interest groups will step up to the plate to fund irrigators to defer the use of their water and take water off the land for irrigation to remain in the creek and streams for the benefit of fish. I would maintain temporary changes of use for fisheries is not an appropriate use that should be exercised with 41.3.110. I would say that these changes to Title 41 need further scrutiny and vetting by the public without any additional amendments. Without amendments that prohibit the use of fisheries, I would request a no vote.
Thank you, Mr. Stewart. Are there any questions?
Madam Chairman.
Go ahead, Senator Hicks.
So Madam Chairman, number 41.3.110 right now, the scenario you described could be done today. What you just described, anybody could come in and do what you just described as file for an in-stream. There's no provision that would stop that today. Would you agree with that? Because there's no language in the existing statutes that says in-stream flows are prohibited from temporary change use. Can you point to me where in the statutes that it prohibits that today? The statute's been on the book for 60 years now. Show me where it prohibits that use right now. Thank you.
All right, go ahead. Do you have an answer for that?
Madam Chair, Senator Hicks, thank you for that. I've been aware of existing language in that statute that shows other purposes. Madam Chair, it's my belief with the additional language included in that statute, it clarifies to anyone suggesting that this is only changes for truly temporary purposes. When examples are given with regard to highway drilling purposes, these are time-limited purposes. And And also, I'm aware of several other changes for temporary use. One of my good friends, a former representative, exercised some temporary changes that were time limited for a month or two. And when the purpose was achieved, the temporary use permit went away. Fisheries do not benefit from temporary changes. And Madam Chair, it is my information and experience watching these past attempts for changes to recognize fish that the current language in statute does not allow this. And I'm afraid that removal of a good example for how these time-limited purposes what they should be, it would overly broaden the statute to allow these things to occur. That's the
Right.
best I can do, Madam Chair.
Mr. Stewart, do you have a proposed amendment for that?
I do not have written proposed amendment other than a general amendment that after other beneficial purposes except for fisheries purposes.
Okay.
Does that make sense?
Yeah,
Thank
we will consider that when we work the bill. Thank you very much for your testimony. Are there any further questions? Seeing none, thank you very much.
Madam Chair, can I comment on 413111?
Oh, yes, yep, go ahead. Super quick.
Thank you, Madam Chair. I'll skip some of my introductory remarks, Madam Chair. My experience in water rights administration, and water rights research. We know that priority administration of existing water rights is already set up to protect the senior appropriator to ensure they get their water before a junior appropriation gets their water. It is well known that the process to change a water right, which I am involved with on occasion with petitions or to the Board of Control, the process to change a water right is set up to protect the junior water right, Madam Chair, to ensure that a senior water right is not moved to a location where it was not before, with the result that the junior right will not be able to divert water when in the past they could. This would injure them and should not, nor is it allowed. Madam Chair, I would opine that the language in 413111 is fine. It does provide clarity, and that these changes only confuse the issue as a result, clearly obvious from the multiple questions about what does this do, what doesn't it do? And in my opinion, Madam Chair, to address the previous good questions from the committee, there is nothing when I read that statute that talks about the timing of what happens and when. And I would feel little comfort that this change would clarify anything, and it would also open the door for some administration that would injure some junior water rights when it should not. So, Madam Chair, again, I have no suggested amendments other than to say that I think 413111 is just fine and does not need to be changed to accomplish your goals of moving water around. Thank you.
All
Madam
right,
Chair.
thank you very much for your testimony. Any further testimony in the room? Come on up. Oh, two more. Well, why don't you come on up? Each one take a chair, and as soon as the other one's done, the next one can go. And we'll just keep moving right along here. Please, welcome to the Senate Ag Committee. Please state your name and if you're with an organization, and whoever, ladies first.
Thank you, Chairman Steinmetz. My name is Kara Choquette. I'm here today on behalf of the Anschutz Corporation's Overland Trail Ranch. The Overland Trail Ranch is based in Saratoga. And I just have one amendment to suggest. Overall, the Overland Trail Ranch supports the bill on page 2, line 18, and that's simply to add the word water before the word rights, so that it says, if it injuriously affects the water rights of other appropriators. Madam Chairman, the review was that in the context today, we all understand, I believe, that this is about water rights, but just to prevent future ambiguity in the statute, to make it very clear we're talking about water rights.
All
And
right.
that is the only suggested amendment.
All right, thank you very much.
Thank you.
All right, any questions? Any questions? Seeing none from the committee, you're off the hook. Welcome, sir. Please state your name for the committee and the record, and tell us who you're with and give us your testimony.
Okay, thank you, Madam Chair. Members of the committee, I'm Jack Berger. I'm a rancher and appropriator from Saratoga. I'll try and be quick. I mean, back to the unintended consequences. That's what this is about, and the beneficial purposes concerns me also. And I just hope the committee understands what regulation does to us. You know, we may not be benefiting from, you know, selling our water or temporary use, but if that makes regulation on the stream, then I'm injured, because we can't bunch water. In short water year, we can put this water right together with this one, and we can get across, you know, the land better. If, you know, if under regulation, you know, you got your foot per 70 here and your foot per 70 here, and you cannot accomplish what you need to do. So it injures us all under regulation. I guess the curtailment's part of this, and it hasn't been spoke to today. Am I correct that that's all part of this bill?
Sir, it's not contemplated in the bill, but we're always looking for solutions that might help us. Senator
Well,
Hicks, did you want to respond to that?
Do we have time, or?
We don't have time to talk about curtailment today.
Okay.
We're specifically addressing the legislation before us because there won't be any action on that issue today.
Okay, I
Other
thought it was
than
part of
through
the
these
bill,
two
but
bills, yeah.
I'll skip that. I'll go to fish then, and the in-stream flow, which is definitely a part of this. And I agree there has to be language to take fisheries, make sure fisheries is not a part of this. Thing that always amazes me about the in-stream flow deal is sending that water down when it's available. When's it available? It's available in May and June. That's when the streams have the extra water to send for in-stream flow. What's the critical time for fish? It's August and September. And if you send that water down the stream in May and June, it's not there for the fish when it's critical for them. If that water spread on the land, you got your return flows. I mean, Trout Unlimited has studies on this about how that water comes back, how it cools the stream, how it increases the volume of the stream and stuff. So, I mean, just the whole thought that we're benefiting fish with the in-stream flow deal is, I think, is completely incorrect. So I would encourage, you know, language about excluding fisheries from this. The other point I'd like to make, I was encouraged by Madam Chair and the committee of your questions about that protecting junior water rights. You know, and that's definitely a real thing. I've tried with 2 state engineers and in the AG's office to acknowledge what Mr. Gephardt just said today. And I was happy to hear him say that about how those junior water rights should expect the flow of the stream as when they were appropriated and stuff. And that's an important issue right there, that they can't be injured. So with that, I'll cut it off there and take any questions.
All right, any questions for Mr. Berger? Questions?
Madam Chairman.
Go ahead, Senator
So,
Hicks.
Mr. Berger, I agree with you on the regulations, but this bill doesn't change that.
Well,
This
it's
could
still-
happen and it increases regulations anyway. And so
Well, it's still an issue.
nothing changes there as far as anybody could go out and has for the ability for the last 60 years to do this. So a specific question is the component on the in-stream flows. And if we need to add that, I think that's probably appropriate, if that's the concern. But when we talk about the juniors, I want to put this in the context. Be careful what you ask for by changing this from priority. Any in-stream flow that was filed today would be a junior water right. By effectually recognizing, now juniors can always call for an administrative appeal if there's injury. That's existing, that'll continue to move forward. But it makes the determination. Anybody can come on to a stream right now and be granted a water right. Because we will grant water rights until there's a determination that there's not any water available. So we had a giant hydrological year last year that there was water way above and beyond almost every river basin in the state of Wyoming. So it's been a long-standing practice of the state engineers to grant new water rights. So the scenario was described with the ranch earlier with their single source of supply. Somebody could come in and file an in-stream flow water right on that. It's a long, arduous process, but that wouldn't preclude that from happening. It's junior. What we're saying now is then if they wanted to exercise that junior water right, that you would have to go under regulation to protect that junior. So it's one of those classic cases. Be careful what you ask for. Do you want to let people that currently aren't on a stream or an in-stream flow filing come in today? And then we have to protect those juniors under that scenario also. So I just say, and we all know water rights administration is very difficult. But so the question, Madam Chairman, is if we include the component that would exclude in-stream flows, would that be something that's acceptable for your organization?
Yeah, and I'm representing myself, but I think that's a must to have the fisheries excluded as part of this. And Senator Hicks, I believe you're incorrect on new water rights. I mean, we're capped on the North Platte. I mean, maybe there's places you can have new water rights, but I don't think that's a general rule that can happen.
All right, well, that might be a topic for another day or in the hallway.
Right.
But thank you for that, Mr. Berger. Any further questions? Thank you for being with us today. All right, further public comment in the room. Come up, Ms. Kennedy. Is there any further comment in the room? If you are wanting to comment in the room, please come on up and sit down in a chair. If not, we'll go, Kim, we can be working on getting Chris Williams in online if they are testifying on this bill. Go ahead, welcome.
Awesome. Thank you, Chairman Steinmetz, members of the committee. Holly Kennedy here today representing Wyoming Association of Conservation Districts. And I am joined online by one of my board members, Chris Williams with the ZN Ranch. So I believe he will have some commentary to add as well. Thank you for the opportunity to comment on this bill. It's certainly a bill with a lot of interest, as I'm sure you have gained from the tone of the room. Anytime we're dealing with Wyoming water law, it of course comes with a high level of concern and looking towards those potential negative consequences. It's one of our most belovedly held right here in the state. And we would like to comment today on some areas of the bill that we perhaps have a little bit of apprehension towards. We do appreciate the addition of the language towards the end of the bill that states that no successive periods to exceed 5 years. We do feel that this needs to remain temporary in nature. And we are very concerned about someone successively applying to continue to use water in this manner. My board personally would feel more comfortable sticking with 2-year terms rather than a 5-year term, as they believe that is truly more temporary in nature. So we would bring forward that as an idea for a potential amendment. We also wanted to comment on previously, the language had a descriptive list of those potential uses. And I do recognize that those were more descriptive than prescriptive in nature. But we would like to also follow up with some of the concerns that you've heard previously, in that my board is very concerned about anything that might be an end around to try to do in-stream flow. And so we are very concerned and see the opportunity to potentially put some parameters in place there. So we would bring that as another potential amendment for your consideration. We too share a lot of the concern over the use of these waters for fishery purposes. I think with that, if it's okay, I might let my board member weigh in a little bit and then maybe have some conclusory comments.
Sure, that would be fine, and we'll take questions at the end for both of you. Chris Williams, are you with us online?
Can you hear me?
Yes, welcome to the Senate Ag Committee. Please state your name and who you're with.
Chris Williams. I'm a rancher in the Platte Valley, and I'm on the WACD board.
All right, go ahead and give us your public testimony.
My testimony is it kind of reiterates what we've already heard. I'm concerned with the ambiguous temporary beneficial purposes. And I'm also concerned with the 5 years. I see some of these purposes and some of the scenarios that I could see would require regulation. And like we've already heard, regulation on these creeks that we irrigate out of, it's very cumbersome, and our irrigation is less efficient if we're required to wait for a response from the state. And I feel like some of these uses could provide certainty of regulation for 5 years, or if it's extended for a longer period than that.
All right, thank you very much for that. Is there any questions for Mr. Williams while we've got him online here? Any questions? Okay, Ms. Kennedy, take us home.
Thank you. I greatly appreciate that. So just in conclusion, a couple of suggestions there for your consideration. You guys well know how important water law is to our state, and how important it is to be sure that we're not causing potential injury to our water rights and to our users in the state. So I would ask that potentially another point of consideration is if this bill is fleshed out enough, or if perhaps this would make a great interim topic where we can have a little bit more time to consider the implications of it. And with that, I would conclude my testimony. Thank you so much for your time.
Thank you very much. And just for the record, it was on our interim topics, and it was at our last meeting, but we will definitely take those things into consideration. Thank you so much for being here.
Thank you.
All right, is there any further public comment? Seeing none, public comment is closed. Committee, what's your pleasure? Moved by Kolb, seconded by French. Are there any amendments on the bill? Amendments on the bill?
Yeah. I'll do one.
Senator Kolb.
Yes, Madam Chair. Page 2, line 18, after the insert water.
All right, page 2, line 18, after the insert waters. Moved by Kolb, seconded by Larson. Any discussion? Discussion on the amendment? Seeing none, all those in favor, please say aye.
Aye.
Opposed, no. That amendment has passed. Senator French.
Thank you, Madam Chairman. I would like to make an amendment on page 2, line 16, where it says temporary beneficial purposes, add excluding fisheries.
Senator French, would we want to say excluding fisheries or excluding in-stream flow?
So Madam Chairman, we do have a proposed amendment here that addresses that issue from the Wyoming stock growers, and I think that language is probably what we'd want to do.
Oh, that was at the bottom of my
So-
pile. I didn't
Yeah.
see that one. Okay. So
So-
let's look at that. Would you,
Okay.
Senator French, would you withdraw your
Yes, I
amendment for
will.
a moment and we'll consider this amendment? I didn't realize there was one for each bill.
Yes, I
So-
So, all right. So Senator Hicks, take it away.
So Madam Chairman, page 2, line 16, after purpose, insert, except for in-stream flows as defined in WS 41-31001.
All right. Would that be acceptable? Now you can go ahead and move that, Senator French.
I would move that, Madam Chair.
Moved by French, seconded by Ide. Senator, discussion on the amendment, Senator Larson. No discussion? Discussion, seeing none. All those in favor of that amendment, please say aye.
Aye.
Opposed, no. That amendment has passed. Any further amendment on the bill? Senator Larson.
Madam Chairman, I would add the rest of their suggestion, page 2, line 23, after years, insert. However, the total length of any transfer, including extensions thereof, shall not exceed 10 years, not less than 30 days prior to the approval of any temporary transfer or extension thereof. The state engineer shall provide written notice to all appropriators on the stream segment that may be affected by the temporary transfer.
It's been moved by Larson. Is there a second on that amendment? Is there a second? I guess that motion dies for the lack of a second.
So,
Go ahead,
Madam Chairman,
yes, Senator,
Oh, my
let
word.
me finish up with Senator Larson. He had his
Okay.
hand up. Go ahead.
Thank you, Madam Chairman. I'll make it shorter then. How about, same thing, cut it off at 10 years?
I'll second that.
so what was the amendment?
It's the second part of the stockgrowers amendment.
I know, but that was
It,
the,
it is, however, it's on page 2, line 23, after years insert. However, the total length of any transfer, including extensions thereof, shall not exceed 10 years, period. That is the amendment. It's been moved and seconded. Discussion, Senator Hicks.
I think it's a good amendment.
All right. Kolb, I didn't, Senator Kolb, I didn't see you waving your hand down there. Go ahead.
Thank you, Madam Chairman. Could they reapply? I mean, my question is, could they then reapply for another temporary transfer in the future after the 10 years? Or that whole scenario on how they applied would be not, we wouldn't be able to do that.
I think Senator Hicks might be able to answer that question. Go ahead.
So the intent of the initial language was to make sure that it was reviewed every 5 years. Under the existing program right now, there was no provision that you could ever stop the temporary use. At some point in time, the state engineer could look at it. We have a number of instances in the state that temporary uses were granted every 2 years for a 30-year period, and that was the intent of that language, is to put the make that review is to determine whether it's still a temporary use. I think to the spirit of the law, it's still a temporary use. But the question that you've asked, right now, it's 5 years. They could reapply for another 5 years, but after that, they could no longer apply for a temporary use. Now, keep in mind, to your question, Senator Kolb, so 1 year they would not apply. My guess is this, if you would talk to the legal experts, they'd say after 1 year of not applying, you could come back and apply for another 5-year permit. Because that isn't explicit in this language. So it leaves that up to the determination, I guess, of the state engineer at that point in time, whether they met the intent of the law. So I think this is not necessarily, is not an unreasonable, very nature of it's supposed to be temporary. When the committee worked on this, that's why we put the duty of the state engineer that you must review those. So I think it's a good amendment.
All right, all right. Due to time constraints, it's time to vote. All those in favor, go ahead, Senator Larson. We are going to vote. All those in favor of the amendment to add a 10-year limitation, please say aye.
Aye.
Opposed, no. That amendment has passed. Are there any further amendments on the bill? Further amendments on the bill? I have one, and you might not like it, but I don't like the language on page 3, and I'd like to strike all the new language on page 3 and leave it the way it is, so that the junior water right is contemplated. If I can get a second, that's my motion. It's been moved by Steinmetz, seconded by Ide. Discussion on the amendment.
Madam Chairman.
Go ahead.
Madam Chairman, thank you. I'll be against this amendment. I think it's okay the way it is. Currently in statute, like we discussed already, it's automatically shut off when the junior right asks for it. I don't know if that's quite the right way to go, but if we add this language, I think we've already discussed that also. They do have a point to be made, and the hydrographer will go out and look at it.
All right.
Yeah, Madam Chairman, and I would agree with that. This affords protection right away for those seniors. Those juniors will be addressed within a very short period of time. This affords much more protection for senior water rights, and that will address the juniors. Right now, the diversions are going to injure everybody until the hydrographer gets out there and makes a decision. So this provides additional protections for those existing senior water rights. It doesn't change anything for the junior as the current scenario. So I look at this as actually protecting those water rights in a much better fashion. So I will be against the motion.
Go ahead, Senator
Thank you,
Ide.
Madam Chair. I seconded that motion. I guess I don't understand the language well enough. I mean, the debate between, or the conversation between Senator Larson and Senator Hicks makes a lot of sense. If it does do what they claim that it does, I would withdraw my second to the motion.
Okay, that's fine. Go ahead, Senator French.
I will second the motion.
All right, it's now been moved and seconded. I just think there's too much ambiguity, so go ahead, Senator Kolb.
Thank you, Madam Chair. Yeah, I believe it, I guess the question at hand, the amendment, I believe the way it's written strengthens the bill and doesn't degrade from it. I think it helps it out a lot. It clearly defines the rights of a senior without, I can't see, degradation to the junior. So I'm okay the way it is, so I'll be a no vote on it. Thank you, Madam Chair.
All right, that's fine. All those in favor of the amendment, please say aye.
Aye.
Opposed? No?
No.
You're supposed to be, yeah, you're supposed to be a no, because you withdrew your second. So the amendment has failed. And we've knocked all the dust off. It's 9:18, so we are going to have to hold Senate File 66 over. But I do want to, is there any further discussion on this bill before we take a roll call vote?
Call for the question.
I have two hands up, so just a minute. Senator French, please? Okay, Senator Larson.
Madam Chairman, I'm for the bill. I think it's good, pretty much good amendments. I'm not real excited about the in-stream flow being put in there. I think there's already protection, if regulation was called to deal with that. But I'll be for the bill.
All right. Kim, did you get all of our amendments okay? Is everything good with you?
Yes, Madam Chairman, I got everything.
All right. Would you please call the roll?
Senate File 65 do pass amended. Senator French.
Aye.
Senator Hicks.
Aye.
Senator Ide.
Aye.
Senator Kolb.
Aye.
Senator Larson.
Aye.
Chairman Steinmetz.
Aye.
5 ayes.
Okay, is there anyone in the room that has traveled from a long way to testify on Senate File 66? Okay, so we will take your comment on Senate File 66, Mr. Berger, and then we have about 10 minutes before we can go into session, but so you'll need to make it super quick because we need to walk up. but we want to be cognizant of your time.
Madam Chair, members of the committee, I think it's real important, and I talked to some of the committee members earlier about having notification in that bill.
Okay?
I think the Sinclair refinery deal would have been a done deal and signed, and nobody to ever known. It would have slid under the radar. It just happened, somebody caught wind of it. And I mean, that's why it's been discussed anyway. So notification's an important thing to add to that.
All right, thank you very much. And with that, committee, we are adjourned
Nope.
until, oh, we're not?
We had another person.
We had another person. Who was it? I didn't see a hand.
Nope. Okay.
You can come back. All right, if you can come back, that would be wonderful. Thank you very much. We are adjourned.